cancel culture is now, and you heard it right in the open, at the U.S. Supreme Court. And let me explain why. The current nominee to be HHS Secretary is, of course, the radical left Attorney General of the state of California, Xavier Becerra. In California, which also is similar to New York and Hawaii, it's the only 3 states that require nonprofit organizations. So I'm not talking about political campaigns, but nonprofit organizations to disclose donors to the state. Now, that does not mean public disclosure. It's not supposed to mean public disclosure. But when California began requiring this disclosure to the state, they had no confidentiality law in place. They actually used college students, part-time workers, people on contract to set up the filing system, and it was immediately, I don't even know if hacked is the right word, accessed, and people who donated to groups that were conservative started getting attacked.
That's why anonymous pamphleteering, as it used to be called, is as old as the Constitution itself. Anonymous giving for the same reason. And while there's some exceptions when it comes to election laws, so that's what they're talking about, campaign committees,
political committees.
The idea that in a general nonprofit organization that you have to start disclosing the names of your donors, those people that right to associate with you is constitutionally protected.
This strikes at the very heart of who we are as Americans and our founding understanding of America, and the central greatness of the United States depends upon having every voice be heard. Jay, you and I aren't going to like some of the voices. We're going to disagree with them sharply. But at the end of the day, America must not allow this cancel culture to take place. We've watched the left for years claim that they were the ones for progressiveness and wide open spaces and free thought. It turns out now that they have power, they want to shut us down. They want to close us out. They want to cancel us. It strikes at the very nature of our nation, and it is a real threat.
California didn't say, oh, we messed up. Sorry, we're going to create a better system. They are fighting back. And this is the nominee to be the HHS Secretary. It's the Attorney General of California, Xavier Becerra, who is fighting back. They're not saying, oh, sorry, we made a mistake by allowing people to access this data. They're saying, no, we don't have to have a confidentiality rule. We don't have to keep all of this so private. We don't have to have this in secure servers like a tax return, even though that's what it's on. The disclosure is like a tax return, and that's not supposed to be public. So this idea that you are going to let donors be threatened to groups, I just want liberals out there to think about this. Think about unpopular movements that started in California that became acceptable nationwide, whether you're talking about maybe a gay rights movement or now the trans movement. If those donors were all made public 20 and 30 years ago, they would have been harassed, unfortunately. There's people out there, bad actors, who don't want to just understand there's going to be speech they like and speech they don't like. We never would endorse the harassment of anybody.
We have filed a major amicus brief, that's friend of the court, and our briefs are read and our briefs have been quoted often by the Supreme Court in its opinions on this. Let me read you 2 sections of what we're saying because I think it sets forth what we're talking about here. There's a standard in the law called exacting scrutiny, strict scrutiny, and we're saying that is inadequate to protect against the chilling of First Amendment associational rights. You have the right under the First Amendment for freedom of association. That means you can collect together, including funding, as we do here at the ACLJ, and advocate positions. And you're not required to disclose it because it's even anonymous pamphleteering at the founding of our country. They would use pseudonyms or they would just be anonymous, including the Federalist Papers, by the way, initially. So, you just have all of this in our history of non-disclosure because it would chill First Amendment rights. And then we said strict scrutiny review is necessary to forestall further chilling of First Amendment associational rights from the dramatic increase in retaliation against those with disfavored political views, and you could easily assert religious views.
If I want to donate to a religious organization, if I want to donate to an ideological cause, if I want to donate to the ACLJ or any group like that, like we are, who espouses conservative causes, and I have to disclose my name as a donor, you're saying to me, put me on the chopping block. Look at me and attack me and target me just as they did with the IRS when they were targeting the exempt organizations.
This gives ammunition to the cancel culture. It allows the cancel culture to reach the next level by saying, now we can target these individual donors. That's the idea of what's going on here. And we've got to fight back on this because it's not just protecting the donors, protecting the organization too.